We're going to be talking about relief that you can get under the order for protection, how do you file it, and how do you do service. So I'm going to start with relief because that's what goes into your actual petition that you're helping somebody write. So what is relief? Relief is what you can ask the court for. So, and this week you're being directed to read some portions of the Order for Protection statute, and the ones that relate to relief are subdivision 6 and subdivision 7. So there are two different lists that are contained within the statute that tell you what kind of relief can you ask for from the court. What can a petitioner ask for in their order for protection? And the lists are different depending if you're asking for an ex parte order for protection or asking what's the relief you can get after a hearing. So it's really important that you understand those differences. So what you can get in an ex parte order or an order where there's no hearing, that's listed in subdivision 7. And what you can get in an order for protection after hearing is listed in subdivision 6. We've also made for you a checklist that kind of groups these things together and combines those two in one document. So that's the checklist that you have in this week's materials. So what kinds of things can you ask for? One of the things that you can ask for is that the person not commit any acts of domestic abuse against you. And that's pretty standard in every order. But then there's things like exclusions. Where can you get somebody excluded from? The house that you live in. That you don't have to own the house, but that if it's a house that you live in, even if they own it, you can exclude the respondent from that place. You can exclude them from your workplace. You can exclude them from other places, like if you're going to school, or if your children are involved, are listed on the order for protection, and there are some safety issues around pick up and drop off. You could exclude them from the children's daycare or from the children's schools. So there's this whole exclusion portion of the relief. Then there are all kinds of other financial relief that you can ask for: child support, spousal maintenance. You can ask that insurance, health insurance, be maintained and not changed. You can ask for return of property. There's a whole host of things that you can ask for in the order for protection proceedings. There's a couple things to be cautioned about. One is to make sure that you're asking for things under the right categories. If it's a limited relief, ex parte order, or an order for protection that's being asked for without a request for a hearing, that's that short list of relief. If you're going to an order for protection and asking for a hearing, or it's order for protection after hearing, there's a much longer list of things that you can ask for. The other thing to remember is that there is a catch-all phrase called other relief necessary for the petitioner or children's protection or safety. So basically, anything that you can, a petitioner can ask for anything that's related back to keeping the petitioner and or the children safe. And that's not defined, and it's really up to the petitioner to describe to the court and to make the link between, I need return of the car keys. Why is that linked to my safety? And so not necessarily difficult to do, but just remember that you might have to help a petitioner make the link between the request for this relief and why it's connected to their safety. So that's the list of stuff around relief. A couple other things to think about is there's also in these subdivisions the information about firearms. That if an order for protection is issued after hearing, so not the ex parte order, but the order for protection after hearing, the court is supposed to prohibit the possession of firearms. And there's lengthy information in the statute about what the court is supposed to order. So a person is not supposed to possess firearms if there's been an order for protection issued after hearing. And so if they have firearms, they're supposed to either turn them into law enforcement, turn them to a licensed firearms dealer, or to a third party. And if they turn them into a third party, the third party is, there's supposed to be an affidavit filed with the court that lists that transfer of firearms. And the firearm transfer is good as long as the order is good. So if the order at some point becomes dismissed, then the firearms are then returned from whoever is holding them or could be. The other thing to realize is that the firearms prohibition is triggered after when there's something set for hearing. So it does not apply to ex parte order for protections or for order for protections with those limited relief, because someone can ask for an order for protection, not request a hearing. And if the respondent doesn't request a hearing, then you're with that limited release list of relief, and the firearms provisions do not apply. And there's also a specific packet just on the firearm, so you can look through that and be clear about how the firearm stuff plays out. So under the relief, critical things to know that there are different relief if it's an ex parte order or an order for protection after hearing. The other thing to realize is that you have to ask for the relief. That if you help somebody file a petition and at that time they're like, oh, no, I don't want child support. And then you get to a hearing and they say, I really would like child support. It may be too late. You can still try and make that request, but the court may well say, no, you don't get to ask for it now. You had to put it in your petition. And the reason for that is that respondents have a right to know what's going to be asked of them before they get to the hearing. So it's really important to go through that list. You can always, at the time of a hearing, say, no, don't want that now. But it's much, much more difficult, and it may be impossible to add in an additional request once you actually get to hearing. Okay, so that's the stuff around relief. There's a checklist, there's some stuff to read, and there's actually a scenario that you're going to be doing this week around the relief issues. The second thing is, how do you file for an order for protection? So you complete the petition, all the various paperwork, including the sheriff notice, that kind of stuff. You then need to bring it to the court or send it to the court, depending on how your court likes to handle things. And then it gets judicial review. And under judicial review, the court can do one of three things: sign it the way you gave it in. They can alter some of the terms or the relief that you ask for and sign it, or they can deny it and not sign. So if it gets signed, then if you've asked for a hearing, they're going to set up a hearing date. And that hearing date should happen within 10 days. If you didn't ask for a hearing and the court signs it, it then gets sent to the respondent. If the respondent doesn't request a hearing, it then automatically converts into a longer standing year or 2-year order. If the court signs it but modifies the terms, it still either goes to the respondent or it gets set for hearing, depending on what was requested. But you want to check to see if the court made any changes or modifications or alterations to the order. The last thing the court can do is the court can decide not to sign the order. If the court does not sign the order, a petitioner can still request a hearing. They just won't have an ex parte order, and they've already had one judge say, I'm not going to sign it. So it may be difficult, but a petitioner has a right to request a hearing and can do that. So that's what happens. So then after it gets signed by a court, then the next step is to get it served. And to get it served, a respondent is supposed to be personally served, means personally handed the order for protection. And this happens most typically with the sheriff's department, but can be served by any law enforcement peace officer. Also can be served by like probation agents, jailers, any of those folks can serve the order for protection. And it's supposed to be personally served. If they are unable to get personal service, someone's either avoiding service or they just can't find them or connect with them, you can still get the order served. And you have a couple of ways this can happen. One is through publication, which is spelled out by statute, and the other is by alternative service. And alternative service is actually the better way to go. It's more likely that the respondent will actually get the order, and it's also easier, a quicker process to go through. So in the statute, this is laid out in subdivision 8, which talks about the alternative service and service by publication. So read through those, that section, and it will walk you through. You have to fill out an affidavit which says, I mailed this to every place I could think of. The last place I knew he lived, I sent it to the respondent's mother's address, I sent it to his workplace, I sent it to his cousin where he's often staying at. Like, I sent it to all these addresses, which are places where the respondent was likely to actually receive the order. And it's like, you file that affidavit saying, this is what I've done, this is where I've mailed it, and the court can ultimately say, yes, we're going to deem or decide or order that the respondent has been served and the case can move forward. So, personal service, that's the way it happens most often. That's what's the best service. If you can't get personal service, you can go forward with publication, or we would recommend going through alternative service. There's one last way in which service can happen, and that's what's called short form notification. And this, it contemplates that if someone was stopped, say, by a traffic cop, and because they had a tail light out, they can go up and they take your license and they come back and they run you through the little computer in their squad car. And if it pops up that there's an order for protection to be served on this person, the officer can fill out this short form that gives the basic information about the protective order, and they give it back to the person in the car, the respondent, and says, here's this short form notification. There's an order for protection that's been issued against you. You need to go to the sheriff's department and pick up a copy of it. But even if you don't pick it up, you've been considered served and the order is valid. So that's the process of short form notification. Any of those, whether you're personally served, served by affidavit, served by publication, served by short form notification, are all good service. And once somebody is served through any of those means, the order for protection is considered in effect, and things can then proceed forward. So read through subdivision 8, which is in your materials, and then we have a true-false series of questions for you to answer around service of order for protections. So after this, listening to this video, read the materials that are listed, the statutory stuff, there's some stuff on firearms, and there's a relief checklist. Then we have you doing 2 exercises this week. One on what kind of relief that you can request, and the second on true-false questions on service. And so hopefully that'll make you feel confident about those materials.